coming with a pen.
Is that mine? I wonder.
I don't know.
Oh, maybe these are the old. Oh, it is. Oh. Hi, I'm Elizabeth Semmel. Nice to meet you. Well, this will be a change for them.
Pardon me?
This will be a change of nobody getting up to the microphone. Hi, Dana Lynn.
How are you?
Good, how are you? I heard your dog is having I know, it's very hard.
Yes.
Very hard.
Thank you.
I just want to thank you for your opinion.
Yes, thank you.
Lunch or what?
Huh?
Is this your lunch?
Spare. I'm an addict.
Oh, you are?
I'm not interested in the other 11 steps. So if you want a Diet Coke, you can always kind of meet a have a stash.
We come up and everybody left.
Yeah. I think people probably needed to.
Okay, so we're just going to sit in place here rather than go back and forth to the podium. And this is going to be like a talk show format. I want it to be, I want you guys to break in and really listen to each other like we always do and work off of what each other is talking about. I'm going to try to guide you to a couple of topics. All right. Okay.
Do you want to wait till there's a few more people in the room? I know.
Well, welcome back to the continuation of the conference with transformation of the capital system trials. So we're here today to talk about the reduction in use at trial and the changes that we see across the trial landscape and the persistent issues that dog us as the death penalty is put into practice at the trial level. But I want to start with who our panel is today, because what we have is a group here that comes at this trial level issue from a variety of perspectives. So immediately on my left is Elizabeth Semmel, who has done capital work at the trial level, but also at the policy level as a director of the ABA Death Penalty Representation Project. She's now the director of the Death Penalty Clinic at UC Berkeley. She is the founding director of that program, and she's also a clinical professor of legal education there. So she's seen this system in a variety of different iterations. In the middle is Judge Tom Price, who was one of the longest serving, if not the longest serving elected judge in the state of Texas, was on the bench for more than 40 years, starting first in Dallas County in the courts at law, then going to the district bench, and then finally serving nearly 20 years at the Texas Court of Criminal Appeals. And it's too bad we don't have anybody from SCOTUS in the room, because what I want to say about Judge Price is 10 years before the Supreme Court recognized in Martinez versus Ryan the right to competent state habeas counsel, Judge Price sought to recognize that in a dissent in a case called Ex parte Graves concerning Anthony Graves, since determined to be innocent and no longer on death row. So you're going to hear some more about Judge Price's views and that set him apart in some ways from the Court of Criminal Appeals. Finally, on the end is Dana Lynn Reeser. Not only is she a graduate of the University of Texas School of Law, she's a Longhorn through and through, having gotten all of her degrees here, and came to the death penalty movement, or the representation place, actually as a PhD student here, investigating the use of lynching. And so she gets drawn into the capital defense world, goes to law school, and then goes to the killing fields of Louisiana and works there with the legendary Clive Stafford Smith, and has a reputation for being able to get life sentences at trial in a place where that's very difficult. Then when Calvin Burdine, who's the victim of the sleeping lawyer Joe Cannon, gets a new trial in Houston, Dana Lynn comes back to Texas, takes that case on pro bono, and after getting him a life sentence, negotiating for that, she founds the Gulf Region Advocacy Center and has not only practiced then capital trial work in Louisiana and Texas, but now is doing so in the federal courts. So she brings also a national perspective to what's going on in our capital system. Now, somewhere along the way, I know that I had the clicker for this thing. Here it is. And so I want to make, in this season of campaigns, some promises today, all right? So the promises are, this is live, it's unscripted, and it's going to be huge, all right? And, well, maybe not that huge. But anyway, what we're going to do here today is we're going to touch on topics that have to do with the trial of cases that we've seen in our experiences, in our differing perspectives, not me, them. And what I would like to do, particularly at the end, is to have questions from you all. But if there's something that's really like a burning issue you really want to ask about, raise your hand and let's get a discussion going. Because what's happening at the trial level really is transformative. And it's something that we can't overlook. So, one thing I want to just point out, in Texas, which, okay, we're the biggest user, right, of the death penalty. I mean, California's got a bigger death row, but we're more robust in putting people on death row and then executing them. Last year, we only have 2 new death sentences. We have a jury that delivers a 3rd death sentence, but it doesn't become final until January of this year. And so that goes from a high of 48 in 1999 down to 2 last year. That's pretty amazing. But it's not just the reduction in new death sentences that we see in Texas. What we're also seeing is a reduction in the likelihood that a jury is going to sentence a defendant to death. And this is something that, as I go out and teach around the country, I think we're seeing in a lot of different places. California and Kentucky, for example, 50% or less chance of getting a death sentence at trial. In Texas, we've fallen from over 80% down to an average of 66% over the last 10 years. I mean, last year we were well below 50% in the prosecution's ability to get a death sentence at trial. So that tells us something about the tethering of jurors to the death penalty. And so this is our jumping off point. And it's this quote from Judge Tom Price in a case very close to my heart, ex parte Panetti, where dissenting from a decision to deny a stay of execution, Judge Price says, I believe that this decline in the use of the death penalty is because district attorneys and juries now have the life without parole option and are less convinced of the absolute accuracy of the criminal justice system. So Judge Price, let's start with you and tell us about how you came to these conclusions, that you believe that district attorneys and juries are less tethered to using the death penalty.
Well, I sort of grew up, actually I did grow up being a judge. I got out of law school in 70, and then I was elected in 74. So I've become a different person probably every other year based upon my experiences. But now we have fewer and fewer cases that are picked by the prosecutors throughout the state in deciding what cases should be tried for death. I think a lot of that, and the last case that I tried as a trial court judge was a death penalty case that took over 5 months to pick the jury. The hesitancy of the prospective jurors was, back then you couldn't talk about parole. So jurors were hesitant even back then, which was over 20 years ago when I tried this case, and the defendant is still on, the accused is still on death row. I haven't been able to find out why, because I haven't been able to hear the case. But back then, the biggest hesitancy of the hundreds and hundreds of jurors that we went through in trying to pick a jury in Joseph Lave's case was their hesitancy to, didn't want to give the death penalty, but really didn't want to be in a position that this person would ever get out of jail. So in this case, the state was saying, if we can't prove to you that this accused was actually one of the ones that cut the boys' throats in this case, could you consider the death penalty? And the jurors were saying, no, no, no. They couldn't unless you could actually prove that there was some connection in the actual physical act of cutting their throats. That, as a trial judge and as a district judge, you hear so many horrible fact situations. My personal feeling back then was the death penalty was a good sentence. As time has gone on, jurors have changed their minds, prosecutors have changed their minds, and I've evolved. My feelings have gone back and forth. As a politician judge in Texas, you're required to talk about what you feel, and for a candidate to get up and say I'm against the death penalty would probably be a sure shot that you're not going to get elected in Texas. So you become a politician. I have changed, and being on the Court of Criminal Appeals has allowed me to broaden the way I think, and I've watched the number of cases that have come before the court, fewer and fewer cases, and I think the hesitancy that these jurors had 20 years ago is also gone into the whole system. I think prosecutors are less anxious to seek the death case except in the most horrible fact situations. Jurors now know that they can give life without parole, and that option is being used more and more. And that was their problem back 22 years ago when I tried Lade. They just didn't want him to get out. And that's sort of been fixed now with the life without parole. They're able to now be told that he will never, ever, ever get out, and that satisfies people. I think they were not all, people are hesitant, have been forever to assess the death penalty. And you stay on death row for so long, I found that victims, the families of the deceased like the fact that they know the outcome. He's never, ever going to get out. They don't have to go through these endless appeals and endless decisions. So I think all those combined, and with my own feelings, I didn't want to come out and say I'm against the death penalty while I was on the court, because I would expect motions to recuse on every death case that came before the court because of my feelings. So I sort of laid back. I even got accused when I came out with my decision in Panetti of being a chicken, that I should have had this decision way before I did at the end of my career. But that would have excluded me from being involved in death penalty cases because I think the court would agree that I should be recused if I didn't believe in the death penalty enforcing one of the laws. So I've changed, prosecutors have changed, and jurors are now satisfied that when they give life without parole, they will never, ever, ever be released.
Well, and that allows me to ask Dana Lynn, do you see any change in defense counsel as you go out and do your work at the trial level? Because the judges talked about judges and prosecutors. So can you talk a little bit about defense counsel here?
About defense counsel?
Well, I'm going to ask Dana Lynn since she's working with them more directly. So can we?
Oh, you are.
Yeah.
Yeah, I think that there's been a big change in defense counsel in the standard of care, of course, with the ABA guidelines, but also in understanding that the cases are not impossible. I think that used to be, we thought that it was impossible, and the sort of conventional wisdom was it was impossible to win if you got to trial, and so so the goal is obviously to settle these cases, and it still is. But I think that there's been enough success and enough the impact of reversals, and that defense lawyers are now sort of a little bit more optimistic. But what we've also seen, I think, is that not only due to the LWOP and due to the concerns about innocence and error rates, but also because defense lawyers are seeing the failure rate of the death penalty and the effect that it has on prosecutors and judges. I think that if you look overall at the data, and I think Sam Gross is here and the work he's done and Jim Liebman on just the failure rate of the death penalty, prosecutions have not been that successful if you look over time. So I think that one of the changes I'm seeing in defense lawyers is recognizing that they can litigate pretrial motions, that they can do more investigation, that they can fulfill the ABA guidelines and work with the tools that they have to pursue these cases in a way that will be heard by prosecutors and judges differently than it used to be. I think that in some ways the arbitrariness of the death penalty, the fact that that judges and prosecutors have felt sometimes that the case law changes in a gotcha kind of way. We see that, statutes, Gregg, of course, the statute is approved, and then along comes Godfrey and Coker, and there's constant tweaks, and I think that courts are recognizing that they weren't given all the particulars. The Supreme Court rulings in all the reinstatement cases are so contradictory internally and so impossible to fulfill that they don't give you particulars. They leave it to the trial courts and the legislatures. And that is a huge opportunity for defense lawyers that we're beginning to recognize and use. And I don't think people really understood before. To my mind, the question is really not why are we now seeing a change and now seeing the numbers go down and seeing the system sort of collapse in on itself. It's really, why did it take so long? Yeah. Because the whole thing is self-contradictory, as we just heard from the last panel, from the very beginning. And I think that defense lawyers are learning how to make use of that. And I think that prosecutors and judges are taking it more seriously because there have been so many reversals. And there have been so many what they feel of as sort of gotcha moments that, now they're listening.
Well, Liz, you're one of these people who's training defense lawyers. In fact, I see even one of them in this room that I know you trained. And you also were there when the ABA began the effort to revise the ABA guidelines in death penalty representation. So, could you talk a little bit about the ABA guidelines and where you feel like they've been effective, but perhaps maybe where we need to go with them, particularly as it affects the trial level?
Well, it's interesting because accidents make history or something like that. Or maybe history is too big a word. But when I joined or became the director of the ABA Death Penalty Representation Project in '97, it really was my first encounter with the guidelines because I was trying capital cases in California. The guidelines were just not particularly on my radar screen. When I got to the project, I was being asked oftentimes by lawyers in states like Texas, Mississippi, Alabama, Louisiana, for declarations about what do the guidelines require me to do. So, a lawyer would say, I can't get resources to hire a pathologist, I can't get second counsel, et cetera, et cetera. So I got pretty adept at, drafting affidavits or declarations that they would then file to try to persuade a trial judge particularly to provide whatever meager resources the trial judge was willing to provide to make some passing effort to comply with the guidelines. But in the course of doing that, I became very concerned that the 89 guidelines simply were not in sync with the standard of practice. I mean, the good news is we all get better, we all do better, we all learn, and the guidelines had not kept up with best practices. The core, of what they stand for and the message they were conveying about quality, vigorous representation was there. So I started a project with some of my students at Georgetown to take a serious look at what would we do if we could persuade the ABA to undertake a serious revision. That was the genesis of it. And obviously, by 2003, we had a whole new set of guidelines. And what I will say, and I say this mostly from my experience teaching at places like the Brian Scheckmeister Death Penalty College, where every year you see 40 capital trial lawyers come with their cases, or at other programs, the prominence of the guidelines in teaching lawyers what they absolutely must do in order to be competent, not to mention effective and vigorous and relentless. I mean, they are a constant at every meeting, at every training session, at every conference. And then I think, and I want to add to this because I think this is important, you get a lot of lawyers coming to sessions like this who, you can put all the PowerPoints up you want, you can provide sample motions, et cetera. The question is, what are they going to do about it? So I think, the guidelines are critically important because if nothing else, they empower lawyers who want to do well, who want to be that kind of advocate. They empower those lawyers. But the question is, how do they force institutions to change? Because the guidelines are not just about this is what lawyers have to do. They're critically, centered on the fact that judicial appointments in capital cases are responsible for, I'll just put it very bluntly, a lot of very bad lawyering, about hundreds and hundreds of cases of bad lawyering. And, systems that tolerate $40 an hour out of court, $60 an hour in court, or a $1,000 flat fee. So the guidelines are important in terms of institutional change as well. And that's, I think, where certainly the ABA has tried to effectuate that institutional change by going state to state, but I think it's been tougher. And so the point I was actually getting to, and then I'll wrap up with this comment, is the trial consulting projects that exist, the Texas Defender Service, the Project ACRE in Pennsylvania, Steve Harbor's project in Florida, the Mexican Capital Legal Assistance Project. I think it's a mistake to undervalue the extent to which those projects, which match experienced capital lawyers with often unwilling or unskilled or underqualified lawyers, really cannot be overstated. Let me make one last comment because I think it's important. We talk about these cases that came into the courts, and I'm still working on some of them that were tried in the 80s and tried in the 90s, with lawyers who did not present any evidence in mitigation. But I think it's important to remember that those kinds of cases are still being tried today by those kinds of lawyers. And so in the last week or two, a case, Horton versus Alabama, involving a defendant in Alabama was just reversed by the Alabama Supreme Court. It was a case that EJI had. Now, this is a 2010 death penalty case. And it involved a lawyer who, the mass of the prosecution's evidence in this case, because the facts to prove guilt were, as we might say, not overwhelming. So instead, the prosecution loaded in tons of collateral criminal evidence, other bad acts the defendant had done to show that he was a bad person, therefore he committed this crime. And this is a lawyer who filed a perfunctory motion in limine to preclude this evidence from coming in, then never objected to it when it came in at trial. And we're talking dozens of prior bad acts. Never objected, and never objected to other kinds of highly prejudicial evidence. This is kind of lawyering 101. Fortunately, the Alabama Supreme Court reversed, but the point is this is lawyering that was going on in 2010. So I think we have to, what I guess I would say is we have tools because of the guidelines, because of some of the wonderful work the ABA has done, consulting projects, and I would say importantly, state capital defender offices. we are better positioned to make a difference at the trial level, and that accounts for significantly for the decrease in death sentences, but we shouldn't delude ourselves into thinking that that the problem of ineffective assistance of counsel has been solved.
Well, I think a lot of that, though, is because I've been a trial judge most of my life, it appears. Judges will sometimes appoint lawyers not based upon how good they are, but how they're going to